Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today. It's very nice to see your faces, and we appreciate your willingness to attend this virtual oral argument. I think we're getting close to actually maybe being done, and maybe we'll be back in person in the next couple of months, so keep your fingers crossed. And we would look forward to seeing you face to face, actually, in the near future. Counsel, we are here to hear argument in the case of Lisa Labon and is it Peter? I mean, he goes by Peter. That's not how you spell his first name, but he goes by Peter.
Labon. Yeah.
Peter Labon. Counsel, if you wouldn't mind, please entering your appearances for the record.
Julie Nelson for appellant Peter Labon.
Kara Porter for appellee.
Thank you. It appears, Ms. Nelson, that you have reserved 5 minutes for rebuttal. That consistent with what you're doing?
Yes.
Is the clock consistent with what you're doing, what you want, I guess, is the best question.
That's great, thank you.
I'll just remind counsel that while you are not arguing, we'd appreciate it if you would turn off your camera and mute your microphone. That'll allow us to concentrate on the counsel who is arguing at that moment. Do you have any questions before we begin?
I don't.
Okay, then please, Ms. Nelson, whenever you're ready.
May it please the court, Julie Nelson for appellant Peter Labon. Today, we need to talk about what does it mean to make an equitable distribution, especially relying on Utah case law that talks about not only the value, but the kind of distributions and how that enables the parties to go forward. And we also need to talk about what a party has to do to present that to the trial court, because we need to keep in mind judicial efficiency, that it doesn't make sense for a party to say, give every possible iteration of a division going forward. But here, Peter discussed the consequences of dividing the estate. Well, he discussed the consequences of selling off life insurance policies. And at the clarification hearing, he explained that the way the court had divided the estate was not going to work. And that's the fundamental question. Was it going to work? Judge Mortensen.
I just want out the gate to make sure I understand your position, because I think what you're saying is that the court should have given more evenly divided the cash, and then more evenly divided the life insurance policies. Or are you saying that the court should have ordered the life insurance policies sold or surrendered? Sorry. And what I'm wondering about is that his testimony was there might be a tax consequence if I were to surrender them. But if the court had ordered them to be surrendered, then for sure, instantaneously, there would have been a tax consequence. Am I understanding that wrong?
No, you're understanding that right. And you gave me two options, and either option would have been okay. The first option was that we more evenly distributed the cash and the investments. The second option was that we ordered some of them sold. Now, the second option may have turned out to be equitable, but I think it would have minimized the estate. It would have caused tax consequences that really weren't necessary. The first option that you described, which is the one that we think would have been the better one, would have allowed the parties to make their own decisions about whether and when they wanted to surrender those policies. And more importantly, it would have kept all of the value in the estate at that time, right? If the cash had been divided more evenly, then maybe several years from now, the parties may have decided that they wanted to surrender those policies, but maybe they would have been able to grow. But as it was, the investments, and it's not just the life insurance policy, there were other investments as well. The Sonar 2 policy, it's not a policy, the Sonar 2 investment was given to Peter, even though we had a value, but the testimony was clear that Peter couldn't have sold it that day for that amount. We knew it was a risky investment. We knew that even if it paid off, it wasn't going to pay off today. And so Peter was left in a position where he had assets on paper, but they weren't really usable in the way that Lisa's assets were usable. Judge Pullman.
What do you think the court should have done then with the Sonar 2 investment?
I think it could have, like, it's okay to give some of the investments to Peter, but balance it out. It could have probably not ordered it sold, because I think that also would have minimized it, but Peter needs some cash in order to account for the equalization payment, the alimony and child support payment, and that deficit that everybody knew both parties were running up every month. I think, Judge Mortensen.
They both got $3,077,000 net from a house being sold in Park City, right?
That's right.
And he bought a new house for $1,560,000, right?
That's right. They both did
So
that.
he's left with $1,517,000 in cash, no?
Well, some of it got spent. What we actually see in the balance sheet, and it's attached to the decree, is we see about $56,000 in cash, and we see about $661,000 in other investments in brokerage accounts. Now, Ms. Porter described those as being after tax, and she's right to the extent that they're not like 401k dollars, but that doesn't mean that they can be liquidated without any sort of cost to them. And it's important to note that even there, Lisa got $1.1 million in that format. So Lisa's still really far ahead. Now, another thing about that stipulation that's important, and it's stipulated Exhibit 1, is that the parties then considered it their separate property going forward with no claims against each other's property, holding each other harmless against it. And Ms. Porter's argued that perhaps he should have used his separate property to offset the payments to Lisa or his own deficit, but that doesn't change the fundamental problem that Lisa doesn't have to do that. Peter does. And so not only is it unfair, it's also killing off the golden goose, which is supposed to support Peter, Lisa, and the kids, right? There are 4 kids, all of whom are dependent on Peter. Only 2 of them are minors, but the other 2 were like college age. So Peter's supporting this whole family, and he's supposed to be doing it with these investments, but the court's decision is requiring him to sell those off. Judge Pullman.
But I think the problem here, because I think your argument is somewhat persuasive, except for the fact that there's just no evidence that he does need to sell these. And that's the problem the court identifies. I mean, I understand what you're saying about, he doesn't bring this up until later, but when the court has that clarification hearing, there's no argument that the court did it wrong. The attorney just asked the court to provide additional reasons for why the court did what it did. She doesn't say you erred. She doesn't say he can't do this. She says, I need additional explanation for why you thought this was fair. And so
that's not exactly right. She does say he doesn't really know how he's going to do that. He's not going to be able to.
But there's no evidence ever offered that he was going to have to sell these. He says, I want to continue in the investments. He's the one that understands the investments. I mean, this is the testimony that comes out at trial. And so I'm trying to figure out how I would conclude that this court was acting unreasonably when Peter never says, I've got to sell this stuff in order to have the liquidity I need to survive.
Okay, I understand. So 2 responses. The first is that Peter's testimony at trial was, I think looking at 1090 is the right place to look. It was that he intended to keep investing, but he never said, please give me all the investments and no cash, right? He said, yeah, my intention is to keep investing going forward. And Judge Holmberg agreed that that was Peter's highest and best way of earning income. So the testimony that he intended to invest only goes so far. The other thing that's important was that there wouldn't have been evidence about it because this was not the intended division in Peter's mind. Peter's mind all along was you should divide it equally. And if you divide it equally, I won't have to sell anything, right? So let
me jump in there. Was it her proposed division though? Did she ever propose that she should receive investments or the life insurance policies so that, and I guess the question is, should Peter have anticipated the court could reach this division given the nature of what she had requested?
Well, she actually requested it as a penalty. We see that in her proposed findings around 1730 and 1731 that he'd always done this and, she hadn't been involved. So there's that. But I think the question that you just asked is the fundamental question here is how many scenarios do you have to anticipate? I mean, should Peter have anticipated, well, I'm going to get all the investments and she's going to get all the cash? Or should he have started saying, well, what if she gets 25% and 75%? What if it's 30%? What if it's 70%? What if it's 50%, right? The taxes are going to change depending on how the ultimate decree shakes out. And I think this is a way in which divorce is different. In a normal civil action, you're just like, okay, you win. But in a divorce decree, you've got this pile of things and you kind of use your scalpel and you divide them up. It's not until people actually see what the court's done that they then can say, wait a minute, that's not going to work. And then we go to the clarification hearing and we say, that's not going to work.
Does that, Ms. Nelson, does that suggest to me that we need to sort of reconfigure, rethink about the preservation requirements in divorce trials, right? Like, does this mean that automatically parties, if they feel like the court's property division is somehow inequitable, that they have an automatic right to challenge that post hoc? I mean, they do.
They do in a post-trial motion, right?
Yeah.
And I think that's the perfect use of a post-trial motion in a divorce case. Now here, I would note that the clarification hearing was before the decree was even entered. So it's not post-decree, right? We're in a period in between findings and decree. And I think we have to. I don't see how we can impose on parties the burden to imagine every possible configuration, right? The preservation requirement requires that you present your case. It doesn't require that you present your case and the other side's case and all the other possible iterations of it. You present your theory, and Peter did that.
Then why wasn't it incumbent then on Peter to bring a post-trial motion? And to even say to the court, look, I couldn't have anticipated this. I need to put in additional evidence that I will have to sell this in order to make this happen. Instead of just simply asking the court for some kind of additional findings in its order. I mean, I'm not sure the court really had evidence even still before it to say this is what Peter's going to have to do and it will therefore have this consequence. Simply saying that if he sells, he can't make this work isn't really sufficient.
Well, it's an interesting tangle with these post-trial motions. Are you obligated to bring a post-trial motion if you've brought it up at the clarification hearing? Right? I mean, it does get kind of sticky. What is a divorced person supposed to do in this situation? You present your case, you present it at the clarification hearing. Are you also supposed to bring it up at post-trial? And to be clear, our position was just, why don't you divide the assets evenly, which is what Utah law requires. That line of cases in Burke talks about considering the kind of property. I mean, it makes sense that, you know, imagine you've got a couple that's 40 years old and they have an estate of $2 million, $1 million in cash and $1 million in a 401k. Well, if you give one side the cash and one side the 401k, that's not helpful to the side that gets the 1 million in the 401k. The judge can see that. And if the party says that's not going to work for me, how am I ever going to live? Then we've got an equity problem. And I think that's what we're presented with here. I don't think that Utah law requires him to keep bringing it up in a post-trial motion.
But if the court doesn't,
that he was going to have to because there wasn't enough even to pay the equalization payment, right? The court can look at it and say, oh, I see you don't have enough cash to pay the equalization payment. You're right. And I can see that next month you don't have $17,000 to meet your deficit plus $5,000 to meet your alimony and child support. Like it wasn't something that was speculative or down the road. It was right now. There's not enough cash on Peter's side of the ledger to make that equalization payment or to make alimony and child support next month. So where's he going to get that money? He's going to have to liquidate something. Like it was just a natural consequence of what happened. It's not an evidentiary issue, I guess is my point. It's just a discussion. Here's what's going to happen. I'm into my rebuttal time, so I'll reserve.
Judge Pullman, did you have a question?
that's all right.
Okay. Ms. Porter. Thank you.
Okay, thank you. What we have to look at here is what evidence was presented at trial, what arguments were made at trial. And really, is based on the evidence that was summarized not only in the trial court's findings, but also in our brief. Can this court really say that no reasonable person would have interpreted Peter's own testimony, for example, the way that the judge did? Now, among other things that are pointed out is the judge recognized that Peter was very talented at leveraging these assets. Peter himself said that by the time you took into account dividends and the lower cost of these insurance policies, he was able to get loans at 1% or less. I don't think anybody claims that she would have had the same savvy. The trial court very clearly articulated the differences in their understandings of finances. So those kinds of observations by the trial court are fully supported by the evidence, and they're not really challenged. I do have to address this preservation issue because this is not a gotcha type preservation. I don't even think this is a failure to preserve. I think Peter was keeping his options open at trial. Peter testified for a long period of time, and not once did he say, I'm going to have to liquidate if this scenario, or under any. Counsel said he shouldn't have to anticipate every scenario. He didn't identify any scenario in which he would supposedly have to liquidate. He had not had to liquidate assets in the past, even when he needed to make margin calls, or I'm not really a stock person, but capital calls or margin calls, or even when he needed to make investments. He never had to liquidate assets before. And he testified to that, rightly proud of his prowess in that. So how is the court supposed to say, oh, well, there must, for some reason, all of a sudden, he's not able to do what he's been doing successfully for a decade before the separation? But also, even in the cases cited by Peter, there has to be some kind of evidentiary basis in order to criticize the judge for not making this ruling. The cases cited by Peter all reference evidence that was either in the record or should have been in the record. And some of them specifically make reference to expert testimony. The reason that we pointed out in our brief that Peter couldn't even do his own tax returns is because Peter's insistence now about the tax consequences of what he says he has to do, they can't be based on his own testimony. He couldn't even do his own tax return. And they did have an expert at trial who, perhaps rather tellingly, was not asked to address tax consequences of any particular scenario. And Lisa was clearly making arguments as to division of assets. It's not like there were 1,000 assets and he couldn't guess what was really going to be at the heart of this trial. He repeatedly referenced 9 ways that he had invested, and 2 of the bigger ways was through these life insurance policies. So he knew those were going to be at issue, but still no evidence about even the basis, which of course, so you don't even know how much of a liquidation would even be taxed if you don't have a single shred of evidence about the basis, the tax basis on these items. I mean, in fact, he specifically was asked that. He was given a chance and said, I don't know, I haven't looked at it. So that's why I'm struggling with the argument being made, attempted to be made for the first time in a clarification call that the trial court made clear was essentially for clerical or wording type issues. And then, as we pointed out in the brief, even during that call, it was still placed in the hypothetical. If this happens, he might have to do this. And it was not and it was beyond the scope, and it was not an attempt to say, you've erred in this way. And so the preservation on this one really does matter. And again, I think it's because Peter was keeping his options open at trial. I think that's why this argument was not made. I don't think this was an omission of some sort. I think what it comes down to here is every single case cited by both parties, essentially that materially addresses this issue, talks about the quality and quantity of evidence, or it involves a case where someone was ordered to liquidate something. Well, if you're ordered to liquidate something, that's no longer speculative, right? That whether the liquidation will occur. Yes.
He might not have been ordered to liquidate, but he was ordered to make her a significant cash payment, right? And so I think the argument is, if I understand it, like the court should have seen right in making that order that you've got to pay this cash payment, that he doesn't have the cash on hand to do that. And so it's obvious that he's going to have to liquidate. And if he has to liquidate, then we've got this parade of horribles, right? Where you've got tax consequences, you interfere with the corpus and his ability to continue to earn the money that he's been, the court has identified that he's going to earn. And so if in fact on the paper the court can see, if I order him to pay this cash payment, he's going to have to liquidate some of these assets, shouldn't the court see that that could be a problem?
Well, the problem in here is that Peter's arguments basically ignore all of the court's other findings and all of the evidence to the contrary. For example, the trial court specifically mentioned that Peter had paid off all of the loans on the Pacific Life policy using marital funds. Based on the testimony that we did cite in the brief, it's pretty easy for Peter to get these less than 1% loans on these policies. Well, he had paid off a $300,000 loan. There was nothing against the Pacific Life policy. He could literally come up with that cash at an extremely advantageous rate. Thus, and it would more than cover the immediate cash payment and the other expenses. And that's just on the Pacific Life that he paid down with the assets. There was also space on the
Before you move
Northwestern.
on to the different asset, I mean, but doesn't that then immediately make that asset less valuable if it now has a loan against it, even if it's at an advantageous rate?
I don't know about less valuable. I mean, Peter not only had been successfully generating 4 to 5% on those assets, netting, and he consistently had loans against it. The reason I think it's valuable is because, as Peter explained, you can get not only extremely low interest loans, but you can do it without really meeting some of the more stringent criteria if you were trying to borrow from somewhere else. I don't know whether just using it the way it's intended to be used makes it less valuable. So I'm not sure I would really agree with that. And I certainly don't think that it is beyond all reason for the trial court to not see it that way. But also remember that the finding, the 800-pound gorilla in this case is the finding that there was no credible evidence that he would have to liquidate something, and if he did, what the effect would be. Keep in mind that Peter himself said that it would depend on other things. It would depend on tax basis, tax rate. Peter said it would depend on how whether he had to liquidate would also depend on the sonar investment that he sounded pretty up about enough to, as the trial court found, to invest his mother's money in it. So, and there were loss carryovers that he talked about that they probably weren't going to have to pay taxes for some period of time. You can't, I just don't think Peter afterwards should say the judge should have guessed on each and every one of those factors. When Peter now says it was an obvious issue, well, if it was obvious, then adduce evidence on it. Have your expert look at it, and they didn't. And he did have the other cash that was available to him. And we did cite case law, including one case cited by Peter, that the court can look at all sources of revenue or assets, et cetera, in making these decisions. And so if he had cleared about $1.5 million in cash, and he had put a bunch of it in a bank account or other trading type things that he could withdraw from, that's cash. So basically, and of course you do have his testimony repeatedly that this was his plan, was to have these same types of assets. That's related to why I don't think this makes them less valuable. It's like he said life insurance allows you to basically make investments, have funds to make investments without the drag of a more costly investment mechanism. And that's a paraphrase, but I remember him using that phrase, the drag. I think a lot of what this case comes down to, if you only had time to look at 4 cases, I would have you look at Sellers, Howell, Burke, because it talks about the evidence, and Alexander. But literally every other case cited by anyone comes down to what evidence was adduced or not adduced. I want to look and just see, we heard things like, well, in Peter's mind, this isn't how the trial was going to turn out. You know, it's not, I mean, theoretically, 50% of people after a trial, it may not turn out the way it did in their mind. But you have to, that doesn't excuse you from introducing evidence and actual argument and a meaningful opportunity for the trial court. As I've mentioned, we're not saying that, we keep hearing they shouldn't, a party shouldn't have to assume every possible iteration of how a trial might turn out. But it's Peter himself who says this was an obvious scenario, and he never mentioned it once. So
Well,
I think,
let me just say, I mean, I don't think he thinks it's an obvious scenario. I think he claims that he was surprised by the way the court divided the assets. It just becomes obvious that there's a problem once that division is in place. Do you think that's a fair characterization of what he's arguing?
well, I guess the reason I'm struggling a little bit with that is because some of the testimony that we quoted, he said, and this is not going to be word for word, but it's going to be close. He said, if as a result of these proceedings, I have to liquidate something, then this or that. But what she was asking for was not extreme. There was a very limited number of significant assets at issue. You know, we're not talking about some dispute over the wine that got sold. We're talking about a handful of significant assets, some of which only he knew how to exploit. And I'm specifically talking about the investment, the life insurance investment vehicles. Only he knew how to deal with that. She could deal with cash, because most people can, you hope. He could deal with the other. It was a good way to accommodate what the court mentioned several times, which is the vast difference in their financial, I don't think he said savvy, but in their financial knowledge or understanding. And it was a fair and sensible way to balance that out, because Peter could take care of that obligation same way he had always taken care of obligations, with a lickety-split low interest loan on an inexpensive investment vehicle. It's just not irrational, and it's certainly not so obvious that he doesn't have to produce any evidence of any kind at trial, and that's really what happened. And I think at this point, I would just be rehashing things from my brief. So if there are no other questions, I will go away from your screen.
Thank you, Ms. Porter. Ms. Nelson?
Thank you. I think we need to look at Peter's proposed findings at 160 and 161, 162. It explains exactly what he intended should happen. It explains what to do with each of the each of the life insurance policies. It explains how to handle sonar. It explains exactly what he thought should happen. So it's not a matter of him hiding the ball and now feeling like regret about that. He laid out exactly in his proposed findings how things should be divided to allow the parties to go forward. I think it's disingenuous to say that he just didn't bring it up. And I think that we can also see the evidence that was presented in, I want to point to page 3 and then 7 and 8 of my reply brief. That tells us, that really lays out everything that was discussed. Page 3 says that he says, if we have to sell things here, then there will be a tax consequence. Now, did he say what the tax consequence would be? No, because he didn't know how much he was going to have to sell. He didn't know exactly what it was going to be. We have a 25% tax rate on the alimony. Judge Mortensen.
I'm still stuck, and I've been here going through the what do you call them? The ledgers. my understanding was that when the parties sold the Park City home, that they each went and bought a house, but the remainder of those proceeds were then separate property. Do I have that right?
That's right.
And so what we see in the decree, I'm just getting to the point that you're saying it should have been obvious that he's got to go sell stuff in order to make, for example, the equalization payment. And I don't know, I can't see he as separate property outside of everything in the decree has $1.5 million. Why he can't pay $192,000 out of that? Now I get that you're saying he shouldn't have to. That's not fair that he should have to pay that, whereas she's got a bunch of cash. So I get your fairness side of the argument, but I'm having trouble following the math that he's necessarily going to have to sell anything in order to make the equalization payment.
There were the, well, first, the, maybe I can, before we go look at the ledgers, let's go back to my reply brief at 7 and 8. 7 and 8 in my pages where trial counsel explains to the judge he feels like he has no option but to cash out the Northwestern. He would have, a substantial impact. At the bottom of 8 of my brief, it says he's getting 1.5 in taxable gains, not net. So that's where we see that it has been pointed out. The other side did not at that point say, oh, he's got all this money in the bank. And if we go back and look at the ledgers, we see that in fact, that's not really true. The middle column, that's the separate property columns. And he ends up with $56,790 in cash, and then 1.5 in a house, and then 661 in brokerage accounts. And that's pretty much it. I think that a lot of it went into the house and remodeling the house and things like that. And the house is important for another reason as well. The judge had said, well, Peter historically has made this rate of return. Well, okay, true. But in order to make the $250,000 that the court thought he was going to have to, you've got to work backwards. You end up with a math problem here because the house itself doesn't generate income the way that, say, investments might. And so to include the house in his corpus as things that are going to allow him to generate $250,000, that's really not fair. And not fair mathematically. And Ms. Porter didn't really respond to that ever. But as we start liquidating things off, now, like I said, and Judge Mortensen, like you said, he shouldn't have to. And even if he can, he's still reducing the corpus every single month, and she's not. The fact that she can't manage investments the way that he does is entirely irrelevant. She can hire someone to do it. She has all sorts of options. She can sell it off at that point. That doesn't really have any bearing on anything. The issue, and it was certainly not a basis for it. And even if it was a basis, we've got to give enough money to Peter to work with right off the bat without expecting him to end up making 10, 12, 25% once he's selling things off, when he's dependent on this house and supposed to be supporting the entire family with that. I think that we ask this court to reverse. Thank you.
Thank you, Ms. Nelson. And Ms. Porter, if you would mind. Thank you. We will take this matter under advisement and render a written decision as soon as we can. Thank you for your great briefing, both of you. We truly appreciate it, and it very much helps the court. So thank you for your arguments today, and we look forward to seeing you soon.
Thank you, Your Honors.